Do you want to kick us off?
Absolutely. Welcome, everybody. We're excited to have you today. My name is Amanda Barton, and I am Chief Compliance Officer with Mr. Cannabis Law. The panel today is all about how to win a cannabis license in Kentucky. It is co-sponsored by both Mr. Cannabis Law and CanDev. We have some great panelists here to talk all about the Kentucky licenses, and excited to get started. First, I'd like to introduce you to our panelists. First is Dustin Robinson, who is the founder and CEO of Mr. Cannabis Law. Dustin, do you want to give us a little bit of background?
Yeah, absolutely. I am. Thank you all for joining. I'm the founder of Mr. Cannabis Law. Also the founder of Lumalex Law, which is our law firm that provides legal services. And then also the founder of Eater Investments, which is my investment fund. But Mr. Cannabis Law, really, we set up to really focus on applications and win applications. So we've done application work all over, and we've worked with Julian at CanDev on several applications, and there are certain states where we really need CanDev to partner with us because they're the experts on real estate procurement, and Kentucky is one of those states. And as we go through this presentation, I think you guys will see why. So yeah, that's my background.
Thanks. Julian. Julian Aaron with CanDev. Could you please give us a little background about yourself?
Yeah, hey guys, thanks everybody for jumping on. CanDev is a cannabis development company focused on retail locations, and we help retailers expand into new markets that are coming up on the horizon. So yeah, we're really excited about Kentucky. It's always nice when you see millions of people get access to cannabis that they didn't before. So it's really exciting, and seems like Kentucky's following a route that's going to be a lot more feasible for the market as opposed to some of the other places like New York. They're following more like an Ohio template. So we feel like it's going to be a really strong, robust market for those folks that are looking to enter and give access to the people there. So yeah, we're really excited to work in that market.
Amazing. A quick disclaimer. This presentation is just for your general information purposes. It's not to be construed as legal advice. If you do want legal advice, please feel free to reach out to us after the webinar, and we're happy to talk with you more. We'll get right into it. So in March of 2023, Kentucky's governor signed into law Senate Bill 47 that legalized medical cannabis for Kentuckians beginning in January of next year. This is codified in the Kentucky Revised Statutes, Chapter 218B, which created the framework for the medical cannabis program in Kentucky. Now, the Office of Medical Cannabis in the Cabinet for Health and Family Services is responsible for implementing and administrating the procedures. You'll hear us refer to the cabinet a lot, and that's who we're referring to, the overarching entity that is responsible for implementation and regulation of this market. To date, the cabinet has filed about 17 regulations establishing processes and procedures, both for the medical cannabis businesses, along with cardholders. In April of this year, we actually saw 2 emergency regulations that were filed, and those regulations outline how cannabis businesses can apply for licenses. So that's a lot of what we will be talking about here today. First, I kind of want to jump right into the application structure and how they're structuring their medical program. Dustin, can you explain a little bit about how Kentucky has chosen to structure its medical program?
Yeah, absolutely. So I think the most important thing to understand about how they've structured it is that it's a horizontal structure. So some states have decided to go vertical, some have decided to go horizontal. What a vertical structure is where it's basically one license, like in Florida, that operates the full supply chain. But in a horizontal market, like what Kentucky's doing, it's basically they're providing licenses for different parts of the supply chain. And we'll get into all those different parts of the supply chain. And they're going to be doing this in rounds. So the cabinet basically opens up a round. And the very first round is July 1st through August 31st. So that is the deadline to submit your application. They will start accepting them July 1st. And then the last day to submit an application is August 31st. And then what they're doing is sometime in 2025 at the cabinet's discretion, they'll likely open up other rounds. So right now, the timing of this webinar is very appropriate. Now, you probably should have been thinking about this, weeks ago, but you're definitely not too late if you're just trying to jump on the horse. I know Julian, as his team's been working real hard on procuring real estate for applicants. We've been already starting to draft applications. So, we've already started getting ahead of the ball because we know a lot of people kind of wait till the last minute. So we're getting out ahead of it. But if you're thinking about Kentucky, now would be the time to get all your ducks in a row.
You mentioned there's different types of licenses. Could you kind of go over what those are in Kentucky?
Yeah, so it's basically there's cultivation licenses, processing licenses, producer license, retail license, and then they basically have a safety compliance facility license, which is basically like the testing license. So at the cultivation license type, there's 4 tiers. And the tiers are based on the amount of square footage they're allowing. So the concept here, you've seen a lot of states do this, is that they don't want one cultivator having 1 million square feet of cultivation and basically monopolizing the market. They want to create opportunities for some of the small business owners. So the tier 1 is 2,500 square feet. Tier 2 is 10,000 square feet. Tier 3, 25,000. Tier 4 is 50,000. So that's how cultivation is broken down. Then you have processor licenses, which is essentially processing the product. You have producer licenses, which actually include both cultivation and processing. Those licenses are not available in this round, and tier 4 cultivation are also not available in this round. And then you have the dispensing licenses, which obviously are the entities that will be dispensing the medicine. So what's important though here is that some of the markets have like a distribution or wholesaling market where they have a distribution license. So basically processors are forced to sell to a distributor. The distributor sells to the retailer. Kentucky does not have a wholesale or distribution license. So it's basically the cultivator or processor will be selling directly to the dispensary. So that's essentially how it's all structured. And once again, it's basically broken down the cultivation tiers based on the maximum amount of square feet of grow that you're allowed to have.
Now, have they mentioned how many licenses they will be releasing this round?
Yeah, so I know a lot of people, that we've talked to on the cultivation side, they want to go for the maximum amount of cultivation size, which would be the tier 3 license. But it's also in making that decision, it's important to know how many licenses they're actually giving out. So they're actually giving out more licenses for the tier 1. So tier 1 is they're going to be giving out 10 licenses. Tier 2 is going to be 4 licenses. Tier 3 is going to be 2 licenses. So tier 3, you could have a bigger grow, but there's less licenses available. So it's just kind of you're decreasing your odds of potentially winning if you go for a tier 3. Doesn't mean you shouldn't go for a tier 3, but you got to kind of weigh that out and talk that through with your team. For the processor licenses, they're doing 10, and for the dispensary licenses, they're doing 48. And then there's no limit for the safety compliance facility licenses. So really what's important though for this actual round, there's no tier 4 licenses. I mentioned that before. So no tier 4 cultivation licenses, and there's no producer licenses. So producer is the license that's allowed to cultivate and process. So no tier 4, no producer licenses. So what they'll have in this round is tier 1, tier 2, tier 3 for cultivation. They'll have a processor license. They'll have the dispensing license, and then they'll have the safety compliance testing license.
Can I ask a quick question on that, Dustin? I'm not sure
Absolutely.
if we know the answer. I'm not sure if we know the answer to this, but with that producer license, you can do manufacturing and cultivation, right?
Yes.
So with that cultivation that you can do, is there a limit on the amount of square footage? Is that automatically one of those tiers, and that's totally separate from those license types?
So yeah, since they're not doing producer licenses in this actual round, we don't really know the details around it. So it's
Oh, they're not.
pretty.
Okay. Oh, yeah, you're right.
Yeah.
Sorry.
Yeah, so they're not doing the producer licenses, so we really just don't have much information on how the producer license. But my guess is that very quickly in 2025 is when they'll probably make those licenses available, as well as the tier 4 cultivation licenses.
So this round, there won't be any processing or manufacturing. It's just going to be cultivation products, essentially, like flour and things like this. There won't be any kind of
There'll be cultivation and processing, but no producer licenses. So you could pick either cultivation or processing. but you can't get a producer license that does both of those.
Okay. Oh, I see. Gotcha. Okay. Thanks for clarifying that. It's just a little confusing on my
Now
side.
I'm happy you asked, because I'm sure if you're asking, a lot of the viewers have the same
Yeah,
questions.
yeah.
And by the way, if you guys have any questions, that's a good time to bring it up. You guys could just drop them in the Q&A box. We'll be doing a Q&A at the end of this as well for you guys.
Yeah, ask the questions as we go along. I'm so focused on retail that I was just curious about how that supply chain plays out with the different types of licenses. So thanks for that.
Absolutely.
Yeah, that was absolutely a great question. Now, the entrepreneur in me wants to know, can I apply for multiple license types? Like if I want to try to lock down the whole chain, can I do that in this round?
Yeah, so they do not allow you to apply for multiple license types. So if you're doing a dispensing license, you cannot apply for a cultivation license. If you're doing a cultivation license, you can't apply for a dispensing. Applying for a processor, you can't apply for. So basically, within each license type, you're only allowed to apply for one license type. So that's the rule on that. However, within a particular license type, you are allowed to apply for multiple licenses. There are certain restrictions on that. So, for example, for the cultivation, you could only apply within your tier for multiple applications. So if you're applying for a tier 1 license, you cannot also apply for a tier 2 cultivation license. Also, with the dispensing licenses, you also could only submit one application per region. So you need to be very careful about kind of understanding these rules. What's important also is that like the applicant is based on the ownership. So there are certain ways, if you have partners and you want to play around with ownership and create different entities, that you could potentially structure your ownership in a way to apply across multiple tiers. But it will be kind of complicated and very challenging. That's why you really want to work with, law firm or a consulting firm that is kind of familiar with how these lotteries could work.
Very true. Now, specifically, I know that in order to submit different applications, you have to have a separate and distinct physical address for each location. So Julian, question for you. Have you seen this before where each application has to be tied to a separate property? Is this, a structure you've seen elsewhere?
If an application is submitted on a specific address?
Yeah.
Yeah, that seems pretty common. Some markets don't require real estate locations before you apply. It depends on the market. If it's a social equity market, sometimes they don't require an address because it's just so expensive to hold real estate for a lot of the social equity groups out there. But since this one's just open, it's not a social equity market only. It just seems like they're saying, show us the real estate location you intend to apply with, and then that's a key part of the process.
Right. So myself as Amanda, if I wanted to apply for multiple dispensary licenses, right, I can't have multiple applications tied to one property. But from the owner's perspective, from the real estate owner's perspective, can they have multiple applicants tied to their property? Like, can they enter into agreements with multiple different applicants for the same property? And what have you seen there?
Yeah, it's a good question. I think a lot of people are really focused on this because, like if you're a property owner, it really creates more opportunity for getting more lottery balls into the lottery, a lottery ticket, so to speak. And similar to Ohio, it seems as though Kentucky will allow multiple applications per site address, but it can't be the same owner. Like it can't be the same applicant. It has to be different groups essentially. And so similar to Ohio, Kentucky's following that model, and it's a unique one. But that's how this one is working out.
And I just wanted to interject. We got one question. I know we were going to wait till the end, but I think it's kind of important to talk about this up front. The question was, do you have to be a Kentucky resident? And what's actually really interesting, I know we're probably going to get to this later on. I did want to point out, you do not need to be a Kentucky resident. So, a lot of states have required residency for these applications. And that's been challenged in a lot of state under the Dormant Commerce Clause as being, basically unconstitutional. And several courts have ruled that it is unconstitutional to have a residency requirement. So Kentucky does not have a residency requirement. There is a part of their application where they ask whether you have any experience running a business in Kentucky. But if you don't, it doesn't necessarily say you won't be able to get into the lottery. So there is no residency requirement. I also want to correct one thing I was saying when I was talking about the different tiers. I wanted to clarify, you could only, for cultivation, you could only apply for one application per tier within the cultivation section. So I just want to make sure that was clear with what I was saying. And then there was one other question I might as well just address while it's up here. How's
Go
the
for it.
state viewing ownership to limit applications? So kind of the threshold they're looking at is like the 10% ownership. So we'll get into that a little bit later on in the discussion. But yeah, ownership and how you structure the entities is going to be very, very important as to how many applications you're able to submit. Sorry to interrupt, Amanda.
No, you're all good. And another question actually just came in that I think is relevant since we're talking about it. Someone asked if they can apply for a tier 2 and then the wife apply for a tier 4. First, there is going to be no tier 4 in this application round. It's only tiers 1, 2, and 3 for cultivation. But the rule will allow you, me as Amanda, I can apply for a tier 1, a tier 2, and a tier 3 in this round. You can also have your wife or significant other also apply for a tier 1, tier 3, as long as you're not violating the ownership laws or regulations. So
correct. So yeah, that may be exactly. So just to clarify, no tier 4 is available. An applicant could apply across multiple cultivation tiers. So you could apply for a tier 1, tier 2, and a tier 3. But what you can't do is the husband in this hypothetical can't apply for a cultivation tier 1, but also apply for a processor license. You can't apply, but depending, if you have someone else who you have a relationship with and they create their own entity that they have 100% ownership, then there's nothing stopping them from applying for a processor license. You want to be very careful kind of with that ownership and make sure you're doing everything compliantly.
Absolutely. Thank you for that additional information. So Julian, I want to kind of get more back to the real estate regulations, because I think the real estate is so critical for this particularly for this state. We talked about stacking. As far as stacking, do you have any other insight to share regarding, the stacking of properties or what your recommendation might be? So it's great from a properties owner's perspective, but me as an applicant per se, I don't know that I want to share potentially a location with a bunch of other people. So what are the kind of the considerations that go into deciding whether or not you want to get involved with the property that's allowing stacking?
Yeah, so I just want to go back to that for a second. So based on the regulations, it does not clearly prohibit multiple applicants per address. There is questions that have been posed to the state by ourselves, our attorneys, etc. That there's a lot of people asking for like more clear in writing that it's allowed, rather than it not being in the regulations as a prohibited thing. So it appears as though everybody's proceeding as if that's the case. In these situations with states rolling out new programs, typically they release a Q&A document that clarifies certain aspects of the regulations. And I don't know if they're going to release it, but I expect that they will at some point. And that will help give us more clarity around, the devil's in the details kind of stuff, just kind of like not being quite sure. And then people are having certain strategies and investing in a certain approach. And unless you have something from the state that clearly says something's allowed or not allowed, then sometimes you got to, kind of go another direction, so to speak. So that's just it seems as though that's the case, but the state could always come out and, even though it's not in the regulations, they could clarify how they perceive a certain aspect of the regulations. So right now, most of the folks that I'm working with and our company ourselves, we're proceeding as if the state will allow for stacking of locations. And then in terms of strategy, it really comes down to timing and execution and budget. Like how many lottery balls do you want to put into this thing? I mean, if you're going to have your wife apply and your cousin, there can be some groups that are going to be very aggressive that are going to try to go that approach. But there is a requirement that you can only apply once per region as an applicant, as an ownership group. So like Dustin was saying, you got to hire a really strong consulting and attorney team, such as Mr. Cannabis Law, and make sure you're kind of dotting the I's and crossing the T's and not going against the regulations, making sure you're doing everything compliantly. But different groups have different strategies. We've seen it in, many different markets. A lot of groups are stuffing the lottery ballot if they can. So yeah, it depends on your budget. It depends on your strategy, like what are the chances to win if you apply for so many locations. I've talked to some people that are specific in one region. They really want to win in one region. So there's just many different approaches. And I just recommend that you check with your attorney and kind of make sure you're not, crossing lines on the regulations. And then, each group's just going to have a different approach based on, their goals.
I want to touch on something you mentioned. You talked about regions. So
Yeah.
one thing that is required for dispensaries is if you're going to submit multiple applications, one of the restrictions on the dispensary level is that you can only have one application per region. Talk to me about that. How many, like, what is a region? Like, how many regions are there in Kentucky?
Yeah, so the state's divided up the whole map into 11 different regions. And in each region, there's anywhere from like 7 to 12 counties within each region. And each region has a different demographic and population base. And if you go to our website, can.dev, cann.dev, eventually at some point you can go there and look at it. There's actually a graph or a spreadsheet that we posted that shows the different regions and the population within each region, and then how many licenses will be available based on the population to license ratio is basically what it looks like. And so since there's 11 regions, there's 48 licenses. So the two most populous regions, which are region 1 and region 2, those two regions have 6 licenses, and all the other regions have 4 licenses available. So there's 48 total dispensary licenses. And regions 1 and 2, which contain Louisville and Lexington, those two have about let's see here, the Louisville region, which is region 2, that has 170,000 people per license. So that's got 6 licenses in that region and 170,000 people per license. And in region 1, it's 128,000 people per license. So you could probably say, if you're going to apply for a license, those two regions are going to be the most popular, but they're also going to be the most competition. And it makes sense because you're going to have so much population per license there. So you're going to be able to have a more of a robust business. And then if you look at the bottom of the list, region 7 has only 49,000 people per license available. So strategy is really important here. Understanding where are you going to apply and where are you going to invest your energy in order to put your best foot forward.
Thank you for sharing that resource. That's amazing that you guys put that together. That'll definitely be valuable for people trying to figure out which region they want to be in. So thank you for sharing that research or that option for everybody to go check it out on your website. I appreciate it. Now we do have a question. Can a dispensary move? Can they move their location to a different region?
No, if you apply in a region and you win in a region, you have to stay within that area. You can't go to another region, because when the state announces winners, they're going to announce, 4 winners per region, except for the 2 that have 6. So once they allocate those winners, they're not going to be able to move to another region, because that will throw off the winning amount of groups, And the state does have discretion to deny a license. So if somebody just applies at any old location, even though that city's clearly opted out, and we'll talk about opt-outs in a moment, it's just something that you need to consider for strategy, because you could waste a lot of money on something that's not going to come through.
Definitely makes sense. Now, if I wanted to move within my own region, would I be allowed to stay? As long as I'm staying in the region, can I move my dispensary within the region? Yes,
you can. Based on the state regulations, it is allowed. However, we've had some counsel advise us just to be very careful around, like, if you apply for a location and something happens where like a daycare or something moves in while you're in application, and you can clearly show that the setback has changed since you applied, then they're probably going to be a lot more lenient. If you apply for a location right next to a sensitive use, just because you want to get a lottery ticket in, a lottery ball in there or whatever, the state might look down upon that, because they do have discretion to not allow you to move. And it is a regulatory process, like it takes time. So you could also look at this like a speed to market advantage. So if you apply to a location and you have to move, and how long is that process going to take at the local and state level? Meanwhile, your competitors in the region are getting doors open and making money while you're sitting around trying to fight some local municipality to work a bit faster than you'd like.
Very true. Is there any strategy? I mean, you kind of talked about it as far as like the per capita or like the population of each region, but is there any other sort of type of strategy applicants can utilize when selecting which region?
Yes. So this is getting into the details a little bit more, and it really comes down to, like, there's a big thing that happened in Kentucky that nobody understands, is that the state moved up their whole application process sooner. And what they did is they're saying you can apply for a license between July 1st and the end of August, but a city can opt out, can say if they're going to opt in or opt out to allowing for cannabis retail until January 1st. So all these cities, and then we have somebody that's been working on this full time for the last month or so. All of these cities are like, holy moly, the state is moving this thing up on us. We didn't even know if we want to allow for cannabis yet. So they're having meetings about this. They're trying to figure out, do they want to allow for cannabis retail? So for you as an applicant, you need to understand which city is even opening for cannabis retail and allowing for it based on having a clear ordinance, offering clear zoning and setback guidance. And if a city opts out or is not sure if they're going to opt out, if you submit an application, you're going to have a risk of not being able, and you win, going to have a risk of not being able to move or having to move locations and then losing your speed to market advantage. And you're going to have a risk of the state potentially having an issue with your application and maybe revoking it and going to the next person on the list. So the key thing that we advise or that we're focused on is only securing real estate in cities that have clearly opted in, that clearly have an ordinance that's adopted. And what we've noticed is that in our research and in contacting all of these cities, about 1/3 of cities are opting in based on the ones that we're contacting, because we're only contacting the cities that have a high population base that can support a solid retail store. So about 1/3 of the stores are opting in. About 1/3 of the stores are opting out and having a clear moratorium. And then the third group of dispensaries are basically putting it on the November ballot. So you've actually got a marketplace where you've got a small amount of cities that are opting in relative to, a state with 5 million people. And we're not going to know until November whether or not that city is going to opt in or opt out, because the city can vote on it. So if you secure a location there and you apply by the end of August, the state could award the licenses when they do the drawing in October, but then you won't know until November if the city's even opted in or opted out. So it's really, really clear strategy-wise to make sure you apply in a market that's clearly opted in. And the challenge there is it really limits the amount of licenses or regions that are, let me say it again. It limits the amount of cities that are available, because the cities don't really know, like, they're still figuring it out. They're still having meetings. Some of them are putting it on the back burner for November ballot. So something that we're doing that's beneficial for the folks on the call that want to apply for retail, we're doing all that work on the front end. We're making sure the locations that Cannabis secures are compliant based on the setbacks and the zoning, and also that city's opted in clearly and has an ordinance in place.
Yeah, and I just wanted to jump in there just to reiterate, because this is a really important point, and this is kind of the reason that we partner up with CanDev ourselves, because they're the real estate experts. So there's basically 3 buckets these cities fall in. Either 1, they've opted in, those are good cities to get real estate in. 2, they've opted out, stay away from those cities. Number 3 is the bucket where we don't know yet. Right. And so you're kind of rolling the dice if you get something within one of those cities. So I think it's very, very important that you're super aware of all this stuff. You're following along, like what cities are opting in, which cities are opting out. And not only that, also even in the cities that opted in, also make sure you check the specific regulations for the city, because while the state has put the 1,000-foot requirement from elementary schools and daycare facilities, a city could actually put more onerous regulations. They can't put less onerous, so it's going to be at least that 1,000-foot rule, but they could put more onerous. So if you get a location that's 1,500 feet away from a daycare facility, and you think you're great because you comply with the state law, it is possible that city could have a bigger separation requirement. So you got to be super careful, make sure you're working with the right groups that understand how to look up this stuff, because I've seen in other states, this could go completely sideways when you spend all this time and money on an application and securing real estate only to find out that it's not compliant real estate. Sorry to jump in. Back to you, Amanda.
No, it's a very valid point, and something, that you brought up, that 1,000 feet setback requirement from, it's not just an existing school, but it also is a daycare facility. And I know in Florida, like I feel like there's daycare facilities on like every corner. So it can be very important to make sure that you're aware of all the daycares around your proposed location and making sure that you're complying both with the state and, as Dustin mentioned, your city or county setback requirements. Julian, we talked about the 11 regions. Is this applicable to all license types, or who is the regions specifically, pointed at?
I know it's for retail. Sorry guys, I got some background noise. It just started raining here. Can you hear me okay?
Yes, we can hear you.
Okay, I just want to make sure there's not too much background noise. So I know for retail, there's a limit on the regions. Justin, do you have any feedback on answering that question from like the other aspects of the supply chain?
Yeah, so they don't have the same requirements on the cultivation and processing side. Would you see that in a lot of states? At the end of the day, what they want to like allow the cities to regulate is like the sale to customers or to patients in this context. So they want to be very careful and give the cities the right to figure out, the right zoning and the right use for that. But that doesn't apply when it comes to the cultivation processors and the testing facilities.
Amazing. And then circling back, Julian, real estate is clearly super important to the application as we've been discussing. Do you have any advice to applicants when searching for property?
Yeah, so like I'll just say again what I said earlier, just make sure you're applying in a city that's opted in. If you're going to do this on your own, you just got to be really careful to secure the right location in the right area. And I think the key thing here is timing. Don't mess around, work with your professionals sooner than you think. The last thing you want to do is have, be against a deadline and not be able to submit on time. It can take, there's a few documents that are required for your submission related to the real estate, site plans, floor plans, timeline, security plan. So those things can take a couple weeks to generate depending on which professionals you're working with. The part of the package that we're offering groups that we work with is that we're going to be providing those documents so that they can save a lot of time and effort by using our locations to submit an application with. Does that answer the question, or?
Yeah, no, that's perfect. Thank you. I kind of want to circle back to the application. We've kind of talked about real estate for a minute, so let's get back to the application itself. Dustin, who is eligible to apply for a Kentucky business license, medical cannabis business license? You did mention that you don't have to be a resident of Kentucky, but what are some of the other requirements?
Yeah, so there's really, Kentucky is relatively lax when it comes to this compared to some of the other states. Some states have all sorts of requirements. The entity applying needs to be around for 5 years, all sorts of crazy stuff. Kentucky has made it very simple. Essentially, you cannot be convicted of a disqualifying felony, and there's a list of disqualifying felonies. No one associated with the business can be younger than 21 years of age. You must demonstrate that you have sufficient capital, and you have to comply with the 1,000-foot rule, which is you can't be within 1,000 feet for your proposed location, you can't be within 1,000 feet of an existing school or daycare facility for your dispensing facility. So there's no residency requirement, no 5-year entity requirement. None of that stuff is required. So it really opens it up where, pretty much everyone is eligible. What I will say is the biggest moat around this whole thing is really about having sufficient capital, and we'll talk about that later on. But if you're thinking you're going to apply for with hundreds of applications and different people, you might want to think twice, because the capital that you need to demonstrate you have access to is quite large when you start applying with multiple applications.
Yes, we will definitely get into that detail in a little bit. How does an applicant apply? What is the actual process for applying?
Yeah, so it's all done through a portal. There's several states that do this through portals. Some states require that you submit like a USB. Some states like to see a hard copy. Kentucky has a very specific portal that you have to set up your username and stuff like that. If you're working with a consulting firm like us, like we'll do all that stuff for you. You won't really need to engage with the portal that much. But if you're submitting an application for yourself, you will need to familiarize yourself with that portal. It's going to have extensive information and documents that you will need to submit in that portal. And then also within that portal, you will need to submit the application fee, and the application fee is different depending on what kind of license you are applying for. So for a tier 1 cultivator license, it's 3,000. Tier 2 cultivator, it's 10,000. Tier 3, it's 20,000. For a processor license, it's 5,000. Dispensary license is 5,000, and for a safety compliance facility license, it's 3,000. So that's a non-refundable fee you need to submit with your application, regardless of whether you win or lose. You don't get that money back. So when you talk about applying for multiple licenses, it's very important that you understand that there will be a fee for each application. You will need to pay that fee for each application that you submit.
And what other information is required to be disclosed on the application? We've seen some, we mentioned it's a lottery, which we'll get into later. Some lotteries, it's just a simple one-page sheet you fill out. What is the information that Kentucky is requiring?
Yeah, it's quite extensive. Like, we won't go through all the information required on this call, but I'll just kind of go down like a list of like the main stuff. So you'll need to submit information about the company. So the company name, EIN, the ownership structure. You'll have to have the proposed location with GPS coordinates. I know that's stuff that CanDev could certainly help with. You'll have to have information on principal officers and board members. You'll have to disclose any of the owners that have over 10% equity in it. You'll also, depending on your corporate structure, if you have like parent entities, you're going to have to disclose the parent entity. Generally, we recommend, if it's just if we have a client that's just starting up, we recommend to keep the corporate structure pretty simple for purposes of the application. But we've also represented some companies that are applying from out of state and stuff like that. And sometimes they have quite a complex corporate structure. And so all that stuff needs to be disclosed if that's the case. Information on any physician or APRN that's involved in your company. That's really for like conflicts purposes, since this is a medical industry. They want to make sure that physicians don't have any conflicts there. You have to disclose any felony convictions for any principal officers or board members. And then you'll also have to disclose the entity or individual who assisted you in applying and preparing the application. So there's a lot of disclosure. Unlike some states where it's very simple, just give us the entity name and the EIN. Kentucky, they've got a ton of information that they're looking to collect on you. And it's very important that you're prepared. It is no small task getting all that information collected, especially if you have multiple owners, multiple board members, multiple principal officers. It starts to get way more complex. If it's just one owner, one board member, one principal officer, one person financing the whole thing, much more simple. But as you get more and more owners, board members, and principal officers involved, it becomes quite onerous submitting all this information.
In addition to just information, you also have to submit a ton of documentation as well. There's a whole laundry list. So like Dustin mentioned, we're not going to go over every single thing you have to, but the main things to be aware of, because it does take a long time to put some of this stuff together. Could you kind of run down what are some of the most important things that you have to be able to supply for the application?
Yeah, and look, most of this stuff, if there's a lot of information, but most of this stuff, if you're working with a consulting firm or a law firm, they should be able to provide you with most of this information. But one thing I do warn, and I tell all of our clients this, like, it does require help from the client. The client can't just hire us, pay us money, and then disappear, right? Like, this is really a team effort, because there's a lot of information we need to get from the client in order to put it into the portal. So, for example, some of the information, business entity formation documents. So if you're working with a lawyer, they should be able to provide you with the articles of incorporation, operating agreement, shareholder agreement, whatever that might be. Documentation showing applicant has authority to use the proposed location as a cannabis business for at least the term of the license, so which is 1 year. And that's documentation that CanDev would certainly provide, whether it's a lease or whatever it might be. You need to have a site plan. Resumes of each principal officer and board member, organizational structure. I'm just kind of going down the list and trying to highlight some of the main things. You'll need to have a timeline showing the steps and estimated time that the application should take to begin the actual operations. These are all things that our Mr. Camsell, we're already working on these timelines and kind of creating templates so that when the applications come around, it's much easier for all the clients. But these are all things you need to start gathering. You need a financial plan. We're already building out financial plans and budgets for our clients, documentation of sufficient capital available to the applicant. This is really important. We'll get into this a little later, but you need actual documentation that you have sufficient capital. That's been a huge issue within the entire cannabis space, that people get licenses and then they sit on their licenses forever, so because they don't have the capital to operate. So Kentucky has been proactive there, and they are requiring that you have money either on deposit or through an extension of credit from one or more financial institutions. Now, I think this is interesting that they're requiring that the deposit is, you actually have a deposit within the applicant. That's what they're saying here. Or you have some sort of a loan from, they say, a financial institution. So it's interesting that they specifically mentioned financial institution, because if Dustin Robinson was willing to loan someone $250,000 to show they have sufficient capital, and provide a promissory note showing that, based on the wording here, it's not so clear that would be eligible to satisfy the requirement. So there's lots of different things. I won't go. There's a ton of more documents you need to supply to them, but it's very important that when you read through this, you're very, very very careful about the wording and how they're classifying some of this stuff, so you make sure that you check every single box that is required.
Thank you. I'm gonna try to go a little bit quicker here, just because I do want to leave some time for questions and answers. I know we still have a lot to cover. Julian, can you touch very briefly on like site plans for those people who have never tried to operate like a venture like this? Like, what is a site plan? How long does it take to get? What are the costs associated with it?
Can you hear me okay?
Yes.
Background noise. Just heard some big thunder over here. So site plans is basically like a aerial view of the property, including the parking lot, building, etc. Then usually a floor plan with, layout of the space, retail floor area, storage, office space, etc. Generally, it takes about 2 weeks to get these documents together. It can cost anywhere from $5,000 to $10,000, depending on which group you work with and depending on how much documents they're providing. Additional to the site plan and the floor plan, as it relates to the real estate, is a security plan, because you have to show some sort of, the security plan relates to the layout of the building, and then also a timeline. So timeline for construction, that definitely relates to the real estate. If the building's bigger, it's going to take longer. If the building is in poor shape, it's going to take longer. So your timeline will have to reflect to the state, your plan of attack on getting doors open. In a new market like this, the state wants to know that groups are ready and willing to execute, which relates to the financial requirement to be able to show you have the funds available to take steps here.
You mentioned the timeline. Should applicants be more aggressive with the timeline? I know, everyone's always trying to put their best foot forward and make a good impression. And so they think if they're more aggressive with their timeline, showing they're going to open early, even if it's not feasible, they think it'll give them a better opportunity to win a license. Should people be doing that here in Kentucky?
I would probably run that by your attorney consulting team, like Dustin, if you're going to work with Mr. Cannabis Law. At a certain level, it doesn't matter because they're not going to hold you to it. You don't need to sign anything that says you're going to meet this guidance. In a lot of states, and anybody that's done a construction project, like build a house, it takes months longer than what you intend to for the most part. But yeah, I think being realistic with your timeline can make some sense. I don't know if it's going to really help you to show the state that you're going to be opening the doors in a month after getting awarded the license. I don't know if that's going to really help you because it's just a lottery. It's not like they're going to be selecting you based on that. And then one thing I forgot to add for the last question, and just in general around the site plan stuff, is that you don't need to have an architect stamp your drawings. It doesn't need it. I recommend using professionals, but it's more like you got to check the box and make sure that you're providing them your plan. But if you do win the license, there's likely going to be an opportunity to readdress your site plan, maybe make some changes. They're not going to hold you to the plan that you submit. So also consider that when doing these drawings. You don't need to go crazy and have every single little thing worked out. That's why you can keep your costs down on the front end and not have to invest as much on all of these documents, and really hone in on improving the package once you win the license, and ideally save a little cost on the front end.
Yeah, and I'll just add on the timeline thing, I would say it's way more important to try to be accurate as opposed to show speed, like Julian was talking about. All these things are pretty much, it looks like it's going to be check the box based on the language. They're looking if you have a completed application. If it's completed, it will enter the lottery. So your goal number one is to submit a completed application. And in order to do so, you need to provide a timeline of when you plan to open. It doesn't need to be a fast timeline. It just needs to show a timeline. But it is important that, you know, after the fact, they will try to hold you to your timeline, but you will be able, if you need to, at the end of the day, these are all somewhat estimates. You can submit a corrective action plan. And in every state, corrective action plans, or in some states, they call them variances, like here in Florida, those are very, very, very common. And it's relatively rare that states don't allow those variances or those corrective action plans, but they want to see that you had a good faith effort when you submitted your original timeline or submitted your original site plans or whatever it is. That was what you believed. You put a good faith effort in putting what you believed you were going to do, but things change, capital changes, you might not be able to afford something or whatever it might be. So they allow you to submit corrective action plans. But it's important that, you know, if you don't keep to your corrective action plans, understand that the cabinet could impose actual penalties or sanctions, which is actually set forth in the administrative regulations. So you want to be as accurate as possible, not make any, if this was a competitive application, I'd probably be giving you different advice. I'd be saying, you know, give a very hard timeline and show you're going to be up and running very quickly. And that's what we did for our Florida applications, because it's a very competitive landscape there. In this, they're really looking for completeness. So I wouldn't recommend going crazy on a very fast timeline.
Mark, circling back to sufficient capital, you mentioned they actually have to document sufficient capital. What does that mean? How has the cabinet defined that?
Yeah, so I think this is if you're looking to submit multiple applications, this is the biggest thing that you need to pay attention to, is that you need to show a certain amount of capital depending on which type of license you're applying for. So for a tier 1 cultivator, you have to show 50,000. For tier 2, you need to show 200,000. For tier 3, you need to show 500,000. For a processor license, you need to show 150,000. Dispensary license, you need to show 150,000. For a safety compliance facility license, you need to show 150,000. So, and this money would be like in the bank account or an extension of credit from a financial institution. So perhaps they'll come out with more clarity around that. But as it stands, based on this language, it looks like you will need that money in your account, deposit in your account, or you will need to show some sort of a promissory note or some other sort of extension of credit from a financial institution for that amount of capital. So just to give you an example, if you are looking to apply for 10 retail licenses, right? You want to increase your odds of winning, the lottery. So you want to submit 10 of them. You're going to have a $5,000 non-refundable fee. We talked about that before for each of those applications. So that's $50,000, 5 times 10 applications. That's $50,000 you'll have to spend on non-refundable fees. And then in addition, it's $150,000 for each dispensary license you need to show in funding. So if you're going for 10 licenses, that's $1.5 million in funding you will need to show. So if you are planning to go for 10 dispensary licenses, you should either have a deposit in your account for 1.5 million or some extension of credit from a financial institution for 1.5 million. In addition to the 50,000 fee, you're going to have to pay 5,000 for each of the 10 dispensary applications. So that's kind of what I think is like the limiting factor to submitting, dozens of lottery tickets in the lottery.
It's a very good point, because it's easy to say, okay, I'll do 10 applications, but people need to realize that it is per application that you have to show these funds. So it stacks up very quickly. Briefly, can you touch on the actual, what's the process after people submit an application?
Yeah, so you have to submit it within the application window. I'll kind of run through this really quickly since we're running out of time and we want to get to the questions. So you have to submit application by August 31st. It'll be rejected if you submit it after that. After you submit, the cabinet will acknowledge that they received it. It's just a normal probably email you'll receive that we've received it. What's important though is that if you have any deficiencies in your application, you will have 10 days to respond to these deficiencies. So it's very important if you're hiring consultants or lawyers or whoever to help you, it's very important that within that engagement letter, you look and see if they're going to help you also with the deficiencies. We include that in all of our engagement letters, because the last thing you want is to get this deficiency. You send it to your consultant to help out, and they're like, yeah, that wasn't included in the engagement. You got to pay us X amount of dollars to get this done, or you're just left to kind of figure it out for yourself. So you have 10 days. 10 days goes very, very quickly. We've seen applicants get knocked out and disqualified for not getting it in. Most states have this kind of 10-day requirement to correct. So, but it's also important to understand that if there is anything that's deficient in your application, and we don't recommend submitting an application with any deficiencies, that if it's a deficiency that could be corrected, they're supposed to give you time to actually correct that. And you have 10 days to do that. And then within 45 days of receiving the application and determining it's complete, they're supposed to let you know whether you've been approved or denied into the lottery, right? So this is the first phase, is just being approved into the lottery, whether you have a complete application. But it's very important to pay attention to this language, because I've heard some people saying, wow, they only have 45 days from the time you submit the application. It's not from the time you submit the application. 40 days of receiving the application and determining it's complete. So it leaves them a lot of wiggle room to kind of decide, okay, when is it complete? From the time they determine it's complete, that's when the 45-day clock, or at least that's how my reading is of the regulation. So I think that's a very important thing to know. But they do, based on this timing, this should move relatively quickly relative to some of the other states. That is assuming that there's no litigation, which I would not bet my money that there's not going to be litigation. Pretty much every state has litigation. I don't think we're going to get into that on this call, but I would definitely prepare yourselves. If you're applying, you're in for a long haul. There will likely be litigation. Every state has litigation, and oftentimes that holds back the timeline. So I would say just make sure you're prepared for that, especially when you're dealing with your real estate documents. Make sure the way they're drafted, they kind of should be written into those agreements, something that assumes that there might be some delays as far as these licenses being awarded.
Now, what happens if there's more applications than there are licenses available? What happens? Does it go to scoring? We've kind of touched on it briefly.
Yeah, that will definitely happen. There will be more applications than there are spots. And so what will happen is it will go to a lottery. So the first step, once again, make sure you submit a complete application. If you submit a complete application, then it will go into a lottery.
So just wanted to kind of give you guys an opportunity to make some closing remarks before we jump into the Q&A. I'm trying to be sensitive of everyone's time. For both of you, is there anything unique or different about the Kentucky application process or how they've structured it in Kentucky?
I guess I'll go first, Julian. Yeah, like we noted, there's no residency requirement. That's a huge deal. There's also no specific licenses for wholesale or delivery licenses like some states. It's a horizontal market, it's not a vertical market. And I would say it's not unique in this context, but I will just reiterate the importance of if you're looking at a dispensary, the real estate regulations at a state and municipality level become extremely important, and you want to make sure you're very aware of those regulations. Anything on your end, Julian?
Nope, that's good for me. I think you covered it.
Well, Julian, here's a question for you. Do you have any advice to applicants looking to gain an advantage in this round or trying to be the best they can be? Do you have any guidance for them, or?
Yeah, I would just say work with pros. I think anybody that's watching this call is already working with really good teams. Anyone that's being proactive, we're like, 9 or 10 weeks ahead of the deadline here. So anybody that's watching this is already working with really good attorney groups, really good consulting groups, really good real estate teams. So yeah, just really make sure you dial in on that and get everything really well organized ahead of time. I think strategy-wise, it just really comes down to budget. If you can apply for more locations, you're going to get more lottery tickets, but it's going to be challenging sometimes with the requirements for showing capital. And then, you don't want to show capital from the same account for multiple people, because that's probably going to get flagged and you're going to get disqualified and waste a bunch of money. So yeah, you're just going to be really careful to dot the I's and cross the T's. I would say Kentucky is one of the most exciting markets in terms of having an opportunity to win a license and really, do some do some good work there and get a business up and operating. Out of all the other markets that I've seen with the regulatory process, it's just really challenging. And with no residency requirement in Kentucky, with it being a lottery, it's very clear and concise, their approach. There's not there is questions, don't get me wrong, but there's not a lot of unknown factors like there is in other places that have opened up for licenses. And I also like about Kentucky is they're setting a foundation on a medical level first, opening this market up to cannabis, and then that's going to really set a nice foundation for the future. It'll eventually be able to go to adult use and go through a much smoother process. So we're seeing that right now in Ohio with a lot of groups there now able to open up for adult use, and the market's quite established with the medical foundation.
Thank you for sharing. That's very good advice. Kind of want to jump into our Q&As now. With the few minutes we have remaining, we might run over a few minutes. If you have any questions, please drop them in the Q&A section below. We'll try to power through these pretty quickly. One of the questions is, can you apply for a Tier 1, Tier 2, and Tier 3 cultivation license at the same location? No, it's very clear that for each application, regardless of the type, each one has to be at a different location per applicant. That's pretty clear cut. Someone asked, if awarded a cultivation Tier 1 and Tier 2, for example, would it be at the applicant's discretion to utilize both of those licenses, or will they not award multiple tiers to the same application? Do you guys know the answer to that?
Yeah, I mean, I think the whole idea of the lottery of submitting multiple applications is you can win multiple licenses. And if you want to operate, if you submit 3 dispensaries for 3 different regions and you end up winning all 3 of those, which is kind of rare given the lottery is going to be picked at random. But if you win all 3 of those regions, then you win those 3 regions and you're able to operate in those regions. Similar with cultivation, if you apply for multiple cultivation applications and you win more than one, then you should be able to operate in both of those licenses.
Another question was, can you co-locate licenses? For instance, can a cultivation and processor co-locate in the same building or at the same address?
Honestly, that's something we'd have to look into. We've seen this in other states. We've seen them allow this. We've also seen them disallow. This is something where you'd probably want to talk with an attorney. And there's some stuff, I just want to reiterate, none of this stuff is legal advice. No one should be relying on any of the answers we're giving here. We're trying to give this just for informative purposes. Definitely talk with your consultants and your attorneys on any of this stuff. But from my recollection, from reading the regulations, I don't recall what the answer would be to whether you could co-locate, but it's certainly something we could relatively easily find out.
And I do see that I've skimmed some of the questions. Some of these questions are about after you get the application or after you've been awarded the license, questions about ownership change, things like that. Really, the focus of today's webinar is to focus on how to get that license. So I don't know that we've looked into, I mean, we were planning to address just about the application process today, and some of these questions are getting kind of outside the scope. So I'll open it up for people to reply, but we might not be able to answer today, and it might be something we need to look into because there's some really sophisticated questions here, a lot of details that it's just not an easy yes or no answer to. So please keep that in mind. How will priority be given to applicants on a site if stacking is allowed? Julian, do you know?
Yeah, so we've seen this before in other markets where it's based on the first lottery ball that's picked, essentially. But it's not clear, the state hasn't come out and said anything on that front. So we'll have to kind of see if they do answer that in a Q&A. Typically, that's how you would look at it. If it's a lottery, the group that's highest on the list will get the rights to the license. So we're expecting a similar approach here from the state, but we don't really have that clearly in writing from them yet. So like I said earlier, we'll see if they come out with a Q&A, and that's likely a question that they're going to answer.
Fingers crossed. We love when we get direction from the state. It just makes it easier for everybody. How are they handling the timing of issuing licenses? Since product for dispensaries has to come first from cultivation and processors, that will obviously take some time. Are there any requirements for timing to be operational?
So yeah, so how they're handling the timing of everything, they haven't really come out and said like we're gonna do like the cultivation licenses first, since people need to cultivate in order for the dispensaries to have product to sell, or we're gonna be doing the processing license first. So they haven't really come out with any sort of order, at which, at least not that I know of. Whether they end up doing that, we'll see. But as of now, I don't know of any kind of priority they're putting to make sure that, there's sufficient. But I will say, with the amount of licenses they're allowing, they're allowing a certain amount of cultivation, a certain amount of processing, a certain amount of retail. That's based on some calculation that they did, where we need X amount of cultivators and processors to supply X amount of retail facilities. So that stuff they've kind of calculated, and that's how they've come up with the amount and essentially what they're going to do. We mentioned earlier on that there'll be additional rounds. They will be, what all the states do, the cabinet will be basically assessing what this supply demand looks like. If there's a lot of patients and they're not getting access because there's not enough retail stores open, they'll say, hey, we need more retail stores. Or it might be the case that there's so few patients and there's so many retail facilities that there's just an oversupply of product, in which case they'll probably say, we don't need to issue additional licenses. So those are the kind of things you'll start to see. And like we mentioned, now we're starting to get a little bit beyond just the application stuff. So we're going to try to stick to really just, how to win a Kentucky application. But those are some of the things that they'll start looking at.
A question is do you have to secure the lease agreement or commitment from the landlord before submitting the application? The answer to that is yes. Julian, do you want to touch on why? Like, what do you need to provide during your application to show you've secured the real estate?
Yeah, you need to show a deed, a lease agreement, or a contingent agreement. The contingent agreement would be like a purchase option or a lease option, and these documents have to be binding to show that you have control of the real estate. The contingency is very important. That's something that we focus on. All of our deals that we secure will have at least 12 months contingency period, meaning that you have to secure all local and state licenses and permits before you'll execute on a lease or a purchase of a building. And so you need to have enough time to allow for the lottery to happen, to go through any kind of local processes, to go through any kind of building permit processes. And so having a contingent agreement is key when you use these locations. And that's something that we do on our side, where we make sure we secure locations with all of those ducks in a row.
Another thing, just to add to that, I know Julian's group is very careful about this, but if you're not working with Julian's group, then just be careful. They want to know that you've secured a property that you could actually run your cannabis operation at, right? So there's a lot of landlords, you can't enter into a lease. I would specifically identify in that lease agreement what your operations and use of that property is. That you're going to be using it for cannabis purposes. And the reason why I think the state might be looking for that is because landlords, if you have a mortgage on your property from some big financial institution, most of those mortgages say you cannot use this property for any illegal purposes, or else you'll be in default. Technically, those are federally insured banks that are doing those mortgages. So since cannabis is federally illegal, or marijuana is federally illegal, technically that landlord could be in default on his mortgage if he's leasing to a cannabis business. So it's very, very important that the landlord tenant, that lease, that agreement between them, it's very clear to the landlord what the use of the property is going to be.
We have a question, and I'm not sure exactly which part of the presentation it came in on. It says, do you provide those plans or have access to the people that can provide them? I'm guessing they're referencing the site plans and the plans that Julian was speaking about. Those plans are very specific to location, and they do require some input from you as far as like, how do you want to build out your facility, right? Julian's team, and I'll let him speak, but they do have to have input from you. But Julian, can your team help, with those site plans and with that floor plans and those other things required?
Yeah, that's a part of our package. So any group that works with CanDev on our locations will be providing site plans, floor plans, security plans, and timelines. And those documents will be provided with enough time for you to review them. And if you want to make any changes to them, we'll also be providing editable documents. So that way you'll either be able to submit the documents we provide. They're going to be more generic and would work for all groups that would apply. But each group's different. Each group, maybe you want to change how you do a layout, or maybe you want to change something about the timeline, or whatever the case might be. So we will be providing those documents in editable format. And because we're already picking up locations in Kentucky, and maybe I can get into this at the end, we're already beginning to get documents put together for some of our locations to get ahead of things. So groups that work with us will be able to have enough time to make sure they're submitting a complete package.
Yeah, and just to add, they just put plans. So I don't know if they were referring to site plans, but you have to submit security plan, operational plan, record keeping plan. There is a lot of stuff. That's the stuff that our firm is currently drafting, right? And the way we kind of operate is when you engage with us. That's why we're partnered with CanDev. They kind of have the real estate and the site plan. So when you engage with us, we're kind of the quarterback. Like we get it all done. So any plans that you need, you could rest assured they're going to get done when you engage with us. Most of it, for the most part, we draft ourselves, but certain things like site plans, those things will come from a group like CanadaDev to get it done. But there's a lot of documentation, a lot of plans, a lot of SOPs you're going to have to submit. We didn't get into this, but even after you win the license, there are several SOPs you'll also submit once they announce you as a winner in the lottery before they actually award you the license. And we draft those SOPs for you as well.
A question for both of you. Are you working with just retailers, or are we open to working with everybody?
So on our end, we work with everyone. We work with everyone from cultivation, processing, dispensing, testing facilities, everything. I believe CanDev, Julian, you can answer, but I think you guys are mainly focused on the retail.
Yeah, we're just focused on retail locations. We just really keep our head down in one lane. On the real estate side, because we're buying real estate and then we lease locations to our retailers, where you really spread yourself too thin and try to do everything, it really makes it more challenging. So we've just gotten really good at that one use type.
Yeah, and I'll just say that we do have already several people that own cultivation and process facilities that they want to use for processing that are looking to partner up. So, CanDev is our go-to on the retail side, but we also will have access to some real estate on the cultivation and processing side.
I don't know if you guys know this. There was one question about Schedule 3, the reclassification of cannabis from Schedule 1 to Schedule 3. Is that going to have an impact on the real estate or the financial institution comment?
Will not. Schedule 3, there's a lot of, this could be its own call, so I won't spend too much time. There's a lot of misinformation around what the implications are of cannabis going to Schedule 3. It will not impact much of what you're doing. What may happen is moving to Schedule 3, it's still, this operation will be considered federally illegal, even as Schedule 3. Schedule 3 allows a Schedule 3 compound to be prescribed by a doctor if it's FDA approved. You guys aren't providing medicine that has been prescribed by a doctor that is FDA approved. Therefore, you will still be operating federally illegally, even if cannabis is moved to Schedule 3. For example, ketamine is Schedule 3. It's FDA approved. You can legally obtain ketamine through a doctor's prescription. Usually if you're going into surgery, they will give you ketamine. Now some ketamine clinics are opened up that are doing it for mental health. That is legal. Buying ketamine from some guy on the street or some retail store, that is illegal. Even though ketamine is Schedule 3, same thing for cannabis. When it goes to Schedule 3, or if it goes to Schedule 3, if and when it goes to Schedule 3, it will still be considered, your operation will still be considered federally illegal. That does not change.
Thank you, gentlemen, for all your help today and explaining everything that's going on. I know we didn't get to all the questions. If you would like to reach out, I want to give you guys an opportunity to share contact information. If any of our attendees would like to reach out and discuss this matter further or would like to engage with either of our firms, please reach out to us. Julian, do you want to share your contact information or where people can find you?
Yeah, I'll write that down in the chat right now.
Yeah, I just put ours in the chat. You could reach out to info@mrcannabislaw.com and Julian will drop that in the chat as well.
Okay. I can't seem to change who it's being sent to. Anyway, I just want to say, just to finish up, I highly recommend you guys consider working with Dustin and his team. I've been really impressed with them over many years. These guys are on the game, on the button with everything. They've got a lot of experience submitting a lot of applications in pretty much every market. And we speak on a monthly basis, or even twice a month, I think, actually. And his team are great. Highly recommend you guys consider working with them, and lean on them for all the help when it comes to getting all your documents in order, making sure you got your entity information filed. These guys just got a track record that I'm really impressed with. So, if you need help, definitely recommend their work.
And I feel the same about CanDev, and that's why we work together. So, you know, we're a strong team. That's why we wanted to do this presentation together. So really appreciate everyone attending. Like Amanda said, I put our info right in the chat. We'll also send out an email with CanDev's information to all the people who attended. So we'll shoot out a follow-up email. So if anyone has any other questions, they're welcome to reach out. So thank you, everyone. We appreciate it. Have a good one. Bye.
Thank you. Bye.